She received a B.S. degree and a J.D. from the University of Alabama. Her practice focus is primarily in the area of Social Security disability. So we want to welcome her to our microphone today. Ms. Dansby, thank you very much for being our guest today.
Thank you for having me, Beecher. I'm happy to be here.
I'm just tickled to death. In the realm of Social Security, how long have you been an attorney with Social Security?
Well, I've been in private practice for 17 years. Prior to that, I worked for the Social Security Hearing Office for 5 years.
Now, what constitutes disability under Social Security?
Well, Social Security disability is designed for people who are no longer able to work. It can be due to an injury, an accident, or for medical reasons such as diabetes or arthritis, almost anything that can keep someone from working. Under Social Security rules, the person has to be disabled or expected to be disabled for at least 12 continuous months.
And how can one determine how you expect to be disabled?
A lot of that depends on the nature of the illness.
Okay.
Something like arthritis is not going to be cured.
Right.
If someone has a fracture of their leg bone, that's usually not going to last 12 months.
Yeah. Okay. Now then, does that mean someone has to be off work for 12 months before they can apply?
No, sir. That's one of the myths that's out there. In fact, I've even heard of some attorneys telling people to wait 12 months to apply. You can apply at any time. And I always encourage people to go ahead and apply if they think they're going to be unable to work for 12 months, because you can always drop the claim if you're able to go back to work. But there's a huge backlog and there's a long wait, so the sooner people can get their name on that list, the better.
What types of Social Security disability benefits are available?
Okay. There are several. The most common one is just what we call Social Security disability. That's based on what a person has paid into the system while they're working. There's also SSI. That's the needs-based program, and that is for children or people who have never worked and paid in. It's basically a needs-based like food stamps or something like that. Someone has to be indigent.
Yeah.
Then we also have widows and widowers claims, and that is if someone becomes disabled who is widowed under certain circumstances, if their spouse paid into the system.
How does one apply for SSD benefits?
Well, there are several ways. The easiest way, in my opinion, is online for someone who has internet access. And that's at www.socialsecurity.gov or www.ssa.gov. Or you can call the Social Security toll-free number, which is 1-800-772-1213. Or a person can go to their local Social Security office and apply in person.
What should a person do if they apply and are denied? A lot of times that's discouraging.
Well, it certainly is discouraging, and a small percentage of people get approved when they first apply. Appeal, appeal, appeal. In most of the United States, after an initial denial, you would request a reconsideration. Alabama, as of right now, is part of a pilot project where we skip that step and we go straight to a hearing. They are talking about doing away with the pilot project, so we may have to go back to the old days where you had to be turned down twice before you could get a face-to-face with the judge. But always appeal.
Always come back.
Absolutely.
As that saying goes, if you fail one time, try again.
Absolutely, Beecher. That's exactly what you should do.
If denied at the hearing level, what should they do?
Okay, I look at a case-by-case on that. There is another appeal administratively, and that is to the Appeals Council. In some cases, though, it's better to just file a new application. But there are several levels of appeal. After the Appeals Council, you can go into the United States court system, starting with the district court. We are in the Northern District of Alabama. Then the appeal from that is the 11th Circuit, based in Atlanta, and then all the way to the U.S. Supreme Court. But as you know, very few cases make it to the Supreme Court, and very few Social Security disability cases make it, but a few have.
And go to court, this costs you every time you have to go up before the court?
No, sir. Well, filing fees if you go into the court, but not at the administrative level. But attorneys charge based on contingency, only if the case is won. There should be no upfront charges, no hourly rate.
So that way, they're going to work harder for you if they're going to win anything.
Absolutely.
Now then, can a person receive both workers' compensation and SSD?
Yes, sir, they certainly can. Now, there is an offset in some cases, but there's no preclusion to receiving both.
Now, back with our guest today, Ms. Kay Dansby. Now, how does SS determine if I am disabled?
Well, they look at your medical records, and supposedly they will gather all of your medical records and have a physician make the initial determination. Then when we get to a hearing level, it's a judge who makes the determination. They look at all of the evidence. They determine how your impairments or diagnoses impact your ability to function. It's not just having a diagnosis. For example, there are a lot of people who are diabetic who are able to control their condition and go to work every day.
Right.
But then there are people who are diabetic, but they have lost their vision, or they have neuropathy, which keeps them from being able to use their hands or from standing or walking. That affects their functioning on a daily basis. We also look at age, education, and work experience. It is more difficult for younger people, not impossible, but it is more difficult for people under 50 to receive disability benefits. Mm-hmm. It's a little bit easier when you turn 50 and easier than that when you turn 55.
What about 75?
Then you're supposed to be on retirement, not disability. Basically, disability is early retirement.
Early retirement.
Right.
Nope.
And then when you reach full retirement age, which varies now, I think mine is 66 and a half, then it would switch to retirement.
Now then, do I have to wait a year after I stop working before I apply for disability?
No, you do not. Remember, we talked earlier about a condition that has lasted or is expected to last for 12 months. And unfortunately, some people are told to wait that year. Never wait.
Yeah.
Get on that list as soon as possible.
What about when you start drawing a Social Security? Now, this is different than drawing a Social Security. You can draw at 62, or you can draw at 65.
That's correct. If you draw at 62, that take the early retirement,
yes, ma'am,
you can simultaneously apply for disability benefits if you're qualified.
Okay.
And a lot of people do that.
Now then, why does it take so long to get disability? Oh, wait a minute. Let's back up a little bit.
Let's
do
go
I have to have an attorney?
No, you do not have to have an attorney to apply. In fact, a lot of attorneys will tell you to apply, and only if you are denied, then come to the attorney. And at that point, the attorney helps. And if I can, I'd like to get off on that subject a little bit.
Okay, that's fine.
If you do decide to get an attorney, remember that you are hiring this person, and you should interview this person just like if you're hiring a secretary to work for you. Ask questions. Look for an attorney who focuses in this area. There are a lot of people who do it a little here and there, but it really takes doing it all the time to keep up with all the changes. Changes are fast and furious in the agency right now.
Right.
Also, non-attorney representatives are in the business, paralegals, if you will. My take on that, of course, I'm biased because I'm an attorney. But why pay the same amount of money for a non-attorney that you would pay for an attorney?
Right.
I always say if I was going to have brain surgery, I wouldn't want a general practitioner doing it. I think it's best to have an attorney, especially when you get to the hearing level, because then you're dealing with a judge. It's intimidating. Kind of like me sitting here talking to you, Beecher. It's intimidating.
Now, I don't know why, Kay, because with your experience, you intimidate me a little bit.
Oh, well, I'm sorry about that.
No, you don't.
There are lots of ins and outs. People are under the impression that they can just walk in and tell a judge, I'm disabled, and the judge is going to see that and award them benefits. It's not quite that simple. There are some pitfalls that an attorney would be aware of. There are ways to maximize past due benefits that an attorney would be aware of. There are laws and rules and regulations that an attorney is familiar with, and generally, an attorney who does this regularly has a good working relationship with the judges and with the staff at the hearing office, and they can guide someone through the system and make it a little bit easier.
It doesn't help to be, so to speak, on the same page with the person, like attorney and the judge.
Oh, yes, sir. Yes, sir. It's a hearing is a non-adversarial process. Mm-hmm. It's an administrative hearing. It is not like Judge Judy. It's not like Perry Mason. Nobody's jumping up and down and screaming, I object, or anything like that. But it's still a little intimidating for someone who's never been through it before.
I see. Now then, what should a claimant do while waiting?
Well, if you have an attorney, You should keep your attorney advised at all times. That one of the most frustrating things about my practice is trying to find my clients sometimes. They change their phone numbers or they move and they forget to call and tell me. And then we get a hearing scheduled and we can't get in touch with them. Also, we like to know all along about any new medical evidence that we need to get. That's one of my biggest jobs, is to get all of the medical evidence in ahead of time. But if I don't know about it, I can't get it.
Right.
So I would say call your attorney. If you're representing yourself, call the hearing office and get your stuff in. But let us know, well, when you've been to a doctor, when you've been to a hospital, if there's been a change in medication, a new diagnosis, or as I said before, especially if your phone number or address changes, we need to know about it.
Why in the world, if, say, for instance, I was your client, why in the world, if I wanted you to do something for me, would I not be cooperative enough to keep you abreast of where I am, my telephone number and so forth, my address, and things like that? But people do, don't they?
They do, and I think sometimes people just forget. Or at one time, this process took a lot longer than it does now. It could be 2.5 years waiting for a hearing, and some people would just think that their case had died, that it had gone away because nothing had happened. They think it's not there anymore.
Nothing wrong with communication, are they?
Absolutely not.
Now then, if my doctor says I'm disabled, does that mean I will automatically win my case?
No, it does not, but it helps. A judge is going to decide the case based on objective medical evidence. Now, one of the things we do is send forms to treating doctors, any treating sources, to try to make it as easy as we can for the doctors. We like for them to be able to just check boxes instead of writing something out. They're more likely to do it. And that opinion carries a lot of weight. In fact, in our circuit, there's an abundance of case law that says a treating source's opinion is to be given great weight. However, that opinion has to be supported. That means that we have to have treatment notes backing that up. I had an example this morning of a doctor who said that his patient suffered extreme severe pain constantly on a form. But in his treatment notes, time and time again, he said, no complaints of pain, no complaints of pain. Therefore, a judge is not going to give a lot of weight to that.
Well, I would think not. You wouldn't have to be a judge to see through that.
Exactly.
Yeah. Well, I tell you what, Kay, our time, I can call you Kay.
Absolutely. Yeah. Please do.
Our time is just about gone, but it's been a real honor and pleasure to talk with you this afternoon and meeting you and just to talk with you about Social Security.
If I may, Beecher, sure. I know I probably haven't answered everybody's questions, and I will be back in my office all day Monday. So if anybody has any questions or would like to discuss anything specific with me, please feel free to call me. My toll-free number is 1-877-834-7001. All right, also we're at www.skdansby.com or dansbylaw.com.
Okay. Okay, thank you so very much, and hope you have a blessed weekend.
Thank you, Beecher. I hope